2 1. This court-wide judgment dated May 6, 2020 decided as to whether the High Court, in exercise of its writ judication under Article 226 of the Constitution of India, could entertain a challenge to the assessment order of the appellant named on the sole ground that the statutory remedy of appeal against that order stood foreclosed by the law of limitation. The SC in the present case, while allowing in the present appeal and setting aside the impugned judgment of the Honorable Hyderabad High Court, Hyderabad HC held that though the High Court have wide power, it cannot issue a writ which is inconsistent with the legislative intent of the concerned statute and in utter disregard of the statutory periods of limitation provides thereunder, as the same would render the legislative schemes and intention behind the concerned provision otis full stop. HC the SC observed that the Hyderabad HC could not have entertained the writ petition of the respondent above named while disregarding the provision of Andhra Pradesh Value Added Tax Act 2005, specifically Section 31 thereof, which provide for the filing of appeal before appellate authority within minimum 60 days. Paragraph. The term periods of limitation has been defined in Section 2J bracket close of the Limitation Act 1963 bracket Limitation Act bracket close as the period of limitation prescribed for any suit appeal of application in the Schedule of Limitation Act. Further prescribed period means the period of limitation computed in accordance with the provisions of the Limitation Act. Section 3 prescribed the general rule that subject to the provision contained in sections 4 to 24, both inclusive of the Limitation Act, every suit institute appeal preferred and application made after the prescribed period shall be dismissed although limitation has not been set up as a defense. Section 3 of the Limitation Act also clarifies when a suit would be said to have been instituted for the purpose of Limitation Act. Paragraph. Section 5 provides that any appeal or application other than an application made under any of the provisions of Order 12 of the Code of Civil Procedure 1908 CPC may be admitted after the prescribed period only if the applicant can satisfy the court that it had sufficient cause for not preferring the appeal or making the application within the prescribed period. Section 5 further clarifies that if the applicant applicant was misled by any ordered practice or judgment of the High Court in ascertaining ascertaining the prescribed period. The same may be sufficient cause within the meaning of the section. Hence, the general rule of law of limitation in that an extension shall not be guaranteed under section 5 if there is no sufficient cause or co- cogent ground for the condonations of delay. The onus of proving which lies on the applicant applicant appellant applicant. Full stop. Paragraph.